wrong place. Sorry.
Trying to duck my responsibilities there.
Before the short adjournment, my lord was asking about expedition and how that was addressed. It wasn't addressed in the evidence and it wasn't addressed in the skeleton argument. It was addressed orally, and that's recorded in the note at paragraph 3.23. That's supplementary tab 7, page 73. Quite short, there's a single paragraph in the note where that was dealt with. And I'm afraid I can't assist further on that point as I wasn't there. I can simply...
73, paragraph...
Paragraph 3.23 of the note, my lord.
Yes, my thought was that somebody somewhere must have justified sticking this into the interim applications list. Generally, you can't just wander up to the interim applications list without at least some attempt to justify that it's urgent, and either it's counsel or solicitors writing to the court or something.
Whatever there was, I'm afraid isn't in the bundles, so I'm afraid I can't assist further on that score. On the other point raised before the short adjournment, the email from Mr. Vesnin to the court, a copy of that's been very helpfully provided. I'm afraid Mr. Harrison and your lordship should have that.
So that's the one on the 13th of March.
Yes. Now, to return to where I was before the short adjournment, I was about to go to Eurasia's trial skeleton and just show the way that the case was being articulated. That's in the appellants bundle, tab 4. And as one sees from the cover page towards the bottom, parties had agreed a list of key issues, so helpfully, and those then track forwards to the bottom of page 39, where the issues are set out. Claimant's position, then Eurasia's position, then conclusion. So issue 1, are the certificates lost? Issue 6, are there encumbrances on the shares? Issue 3, what searches have the claimants made for counter indemnities? Over the page, what is the Article 9.6 discretion? Issues 4 and 5, has Eurasia exercised its discretion properly? Has Eurasia link, that's the registrar, delayed obstructed? If so, has this had any material effect? Issue 7, are the claimants entitled to an order for specific performance replacement certificates? If so, on what terms? So those were the agreed issues as they stood going into the trial. That's what the trial was going to be about. Now, the arguments that Eurasia put forwards are set out beginning on page 47 under issue 6, are there encumbrances? This is the place the third-party claims came into the picture. I don't propose to go through that in detail, but what I do suggest is that the position of the trustee was one point amongst many points taken by Eurasia, and one sees the points identified in bullet form under paragraph 41 and then developed under headings from that point on. We suggest that the position of the trustee was there, it was known about, but it was not the main focus, nor was it the only focus. Sorry, the wrong way around. Now, that brings me to the next point, which is the supposed need for recognition. What the trustee asserts.
Is this point 4, or
this is
this
a
still part of your
sub-point under point 4, my lord.
sub-point under
Sub-point
3? 3 was that you're in your erroneous contentions, and your third one was that the trustee was wrong to say that the trustee was at the front of the
Yes,
party's
but
mind.
this is all under point 3.
Okay.
And there's a related point,
Yeah.
which is the supposed need for recognition. This
Yeah.
is the trustee's contention that he needs recognition, that is an order of the English courts recognising his position as trustee in order to be entitled to oppose recognition at all. Now that we suggest is illogical. It involves saying he needs to have succeeded in one part of his claim to oppose release. What he needed...
Sorry, can you?
Yeah, I think you said recognition in an error.
I'm
said
sorry.
it was an error for the trustee to contend that he needed recognition to oppose
To
release.
oppose release.
I
Yes.
think that's what you
That's what I
meant.
said, my lady. That's what I said, what I intended to say. But that's illogical because it involves saying he needs to have succeeded on one part of his claim to oppose release of the undertaking. What he needed to be doing was bringing forward a claim in this jurisdiction with a real prospect of success, in other words, one that's capable of surviving a summary judgment test, including a claim to recognition, because without that, there's no basis for him to oppose release at all. If he sits in Russia writing letters, that's not a reason to oppose release of the undertaking. Now, he didn't do that until he issued the recognition application. Right up until that point, he didn't advance any kind of claim in this jurisdiction positively of any description at all.
Sorry, I'm obviously, in a sense, the trustee can just write letters.
Yes.
But if he's going to take any step in the English any English proceedings of any sort, then he needs recognition, doesn't he? Because without recognition, the court will just say, "Who are you?"
Well, one can test it this way, my lord. I'll invite my lord to think about it this way. Suppose he'd simply issued an ordinary claim form claim and said this piece of movable property in England has vested in the estate. That cause of action, that claim, involves a series of assertions. Assertion 1, this bankruptcy is entitled to recognition. Assertion 2, as a matter of the proper law of that bankruptcy, the foreign movables vest. Proposition 3, the asset in question was prior to the bankruptcy beneficial of the property of the bankrupt.
Yeah.
Now, suppose he issued that claim, he issued his writ, and he came to Chancery Division and said, I want a proprietary injunction, which would be granted on ordinary American cyanamid principles, because it's a proprietary injunction, not a freezing injunction. He would merely need to show a serious issue to be tried about each element in that claim. Because it's like any situation where it's said some act abroad has vested title to movables in England in me. I have a cause of action to vindicate title to that piece of movable property.
But on that basis, you'd be saying he'd be entitled to get an order from the English court simply by showing there was a serious issue to be tried as to whether he was in fact the bankruptcy trustee and entitled to be recognised.
He'd be entitled to come to England and say the undertaking shouldn't be released or shouldn't be released except on terms once he brought forward a claim with a real prospect of success. But unless and until he did that...
Okay. You're going to have to go back a bit. When we're talking about recognition, my sort of understanding is that that's, as it suggests, the English court recognising the entitlement of somebody who appears in front of them to act on behalf of somebody else by reason of a foreign court order. Because, I mean, the trustee, as I understand it, it says, I now stand in the shoes of the bankrupt.
He does.
But he has to, does he not have to establish that he's entitled to do that before he can then seek to either ask for any other orders or assert any claim in right of the bankrupt that's now vested in him that was
Certainly
vested in the bankrupt? I mean,
to obtain assistance, yes. But if he was simply issuing a claim form claim, and that's the reason I do say one can test it this way, nobody says that a trustee has to come to England, get a recognition order, and then issue his claim, his ordinary claim form claim. He's entitled to say, there's a piece of movable property in England that's vested, and I want to bring an ordinary claim to vindicate my title to that piece of movable property. The constituent elements of that cause of action include the foreign bankruptcy order. So if his title is opposed if the defendant of that claim defends the action on the ground that the foreign bankruptcy isn't to be recognised, that question will have to be tried out. But if the question one is asking is, well, what must the trustee show to obtain a proprietary injunction on an interlocutory basis? It's merely a claim with it's merely a serious issue to be tried, because that's the basis on which the court grants a proprietary injunction. It doesn't, in order to grant a proprietary
It
injunction.
normally grants it to somebody who, in a sense, in relation to whom there is no doubt that they are who they say they are.
Well, indeed.
Whereas in essence, I mean, there's a logically prior question with a trustee in bankruptcy appointed by a foreign jurisdiction, which is, in essence, can you accept that they are who they say they are?
Well, indeed. Indeed.
So I've lost the thread of where you're going with this submission.
Well,
it's my fault, I'm sure. But
No, the point I'm driving at is that it's wrong to say that in order to be entitled to oppose recognition, to be entitled to oppose relief, the trustee needed to have finally established his position as trustee. Because the point taken against me is, well, what was envisaged was a process in which whether the undertaking should be released involved deciding whether the trustee's position should be recognised, because he had no standing unless until he got recognition to say anything at all in relation to release of the undertaking.
So you say it was envisaged that without the question of recognition being heard and determined, he could participate in
He
proceedings.
could participate. He could bring forward his case, whatever it was. Well, suppose he'd come forward and said, I have this claim.
Why are your clients?
Is your point really focused on the ability to get interim relief?
Yes.
In the sense that you say that what is said against you is the mechanism set up by the Tomlin order requires a final resolution of all disputes, if you like, all disputes that come to mind. You say no, because the mechanism provided for by the Tomlin order could flush out those who wish to assert claims. Those who wish to assert claims could go and get interim relief in the normal way. That shows you that the Tomlin order process isn't necessary to carry on until the bitter end.
I do say that, but I focus now on the question of the process of releasing the undertaking, because the argument put against me is that until the trustee has recognition, he's got no standing at all to say anything at all to the court about the undertaking. And I suggest that that is incorrect, that provided he has a sufficiently arguable case to recognition, he'd be entitled to be heard. Now, what the court then does is a different question.
I suppose one way of approaching it is that if there was an urgent application for interim relief in relation to an asset in the jurisdiction that maybe a trustee thinks is going to be dissipated, would the court really insist on the formal process of recognition being gone through to the bitter end before granting interim relief?
My lady,
I'm not. That may be right, but I'm not sure. Well, like my lord, I'm slightly struggling as to where that.
No, that is exactly the acid test. I mean, suppose a trustee comes to England and said there's a piece of movable property in England that's just about to be sold. I say it's vested. I need some urgent relief to protect the position. The court wouldn't say, well, your hotly contested entitlement to recognition is going to have to be tried out before we'll even hear you on an application for a proprietary injunction. Because one can easily imagine a world in which a trustee's claim to recognition is hotly opposed by the bankrupt. The trustee comes to England and said the bankrupt is just about to sell the very valuable property in London and take the proceeds out of the jurisdiction. That should not be allowed to happen. And I do suggest that the court would not say in that situation, we're not hearing you until we've tried recognition out.
And is the reason you're making this argument is to counter the suggestion that it must have been implicit in this Tomlin order that, at very least, the process of recognition should be gone through.
Exactly, Lord. That's exactly the point. That it's not right to say that unless and until recognition was determined, the trustee had no standing to appear and oppose the release of the undertaking. That brings me on to contention 4, which is the contention that Eurasia was in the position of a trustee or stakeholder, that's the trustee's skeleton, paragraph 10, or that or that Eurasia effectively interpleaded. And I do underline that it's Eurasia there. That's the trustee's appeal skeleton, paragraph 18. Dealing first with the trustee or stakeholder point, the assertion is made as a way into the Denak's purpose argument, which I'll return in a moment. But it's, I suggest, fundamentally illogical. The relationship between Eurasia and Q&M was that of company and member. That relationship is not one of trustee and beneficiary, or stakeholder and beneficiary of a stakeholder arrangement. What Q&M contended was that the board of Eurasia had impermissibly exercised the discretion conferred by the articles. They did not say that some piece of property held for them was being misapplied. Indeed, at no point should Eurasia hold some asset on trust for or as stakeholder for Q&M. The shareholding Q&M own in Eurasia is, fairly obviously, a piece of intangible property. But that is not a piece of intangible property which Eurasia owns. It's an intangible owned by Q&M. The only piece of physical property is the share certificate in the hands of the registrar Link for a very short period of time, and the Eurasia action was never about that piece of paper in the sense of who owns it. It's also said in this context that Eurasia was, quote, concerned only to release the certificates to what it referred as the correct people. Now that's a phrase that Eurasia used in its skeleton for the hearing before Mr. Justice Adam Johnson, that's supplementary tab 18, page 270, paragraph 5. But its use of that phrase at that point some months later sheds no light on the proper construction of the Tomlin order. And indeed, it was not the way Eurasia approached matters when the action was being fought out. But one sees that from the pleadings, and if I can invite attention to the defence, this is core tab 9. So this is the re-amended defence of Eurasia. And if I can invite attention to paragraph 2.
Sorry, I was checking another reference. Give me that reference again.
Core tab 9, my lord. Its pleaded case in paragraph 2 is that it does not deny the claimant's right, and I underscore the word right, to request replacement share certificates. Link and the company have never denied this. The company will provide replacement certificates when the claimants comply with Article 9.6 of the Articles. That is when it provides such evidence and indemnity as the directors think fit. Link and the company have always made this clear. So there was no dispute that Q&M, the only registered shareholders of the company that are relevant for these purposes, were entitled to have the certificates. The question was about indemnification. And more than that, the Tomlin order records, as we saw earlier, that Eurasia has determined, that's the phrase used in the Tomlin order, to issue replacement share certificates. Now the consequence of that is that the cause of action sued on in the Eurasia action ceased to exist by accord and satisfaction. Replacement certificates came into being and went into the hands of JHA, held on an undertaking.
Hang on. The cause of action sued on was normally would be stayed. I mean, sorry, the cause of action wouldn't cease.
Well, no, my lord. This is the point about a Tomlin order, where the contractual provisions operate as the settlement. So we sued for an order to compel issue of the replacement share certificates. That action was compromised on terms that they be issued. We could not have had, once they were issued, a continuing right to demand that.
Yes,
So the stay
so paragraph 1 is you stay the action except for the purpose of enforcing the terms. And
Exactly.
you say that following the Tomlin order, it's the terms that can be enforced through the proceeding.
Exactly. The schedule operates as a contract. It's a contractual settlement. It operates as a cord and satisfaction so as to release the cause of action sued upon and substitute a new series of contractual entitlements. The point of a Tomlin order is one then doesn't need to bring a fresh action at the risk of stating the utterly obvious. The purpose of a Tomlin order is so you don't have to go around again and bring a fresh action. It sometimes happens that one compromises an action, the claim is then discontinued or dismissed, and one has to bring a fresh action. Indeed, I recall compromising an action before my lady on those terms. Now that brings me to the next point, which is the contention that Eurasia effectively interpleaded. Now we suggest that's not
Contention that Eurasia, what, sorry?
effectively interpleaded, my lord. We suggest that's not an accurate characterisation. Before the Tomlin order was agreed, Eurasia did not seek to interplead. It did not, for example, seek to join other persons who might assert a claim to the Eurasia shares. That's what an interpleader does. The interpleader is the defendant who is sued, who apprehends a claim by somebody else as well, and brings all of them before the court, and as my Lord Justice Snowden observed, then drops out, and the claims are fought out as between those persons. But that's not what happened in the Eurasia action. There were only ever two parties, three, Q&M on the one hand, Eurasia on the other. None of these other claimants was ever brought into litigation. And once the Tomlin order was concluded, Eurasia ceased to be under any obligation to Q&M because it had issued the certificates and didn't hold them. They were physically in the custody of JAJ. And it was Q&M, not Eurasia, that then brought the matter back before the court. So at no point is it correct to characterise what is going on as being a quasi-interpleader. This isn't somebody who is under a debt, is indebted or holds a piece of physical property, coming to the court saying there are two competing claimants. I don't know which is right. I'm going to bring both of them before the court can decide it. Now, the fact that Eurasia took a neutral stance, and indeed went further and said it's like an interpleader, doesn't really help, because analytically it's not. And I might add a point here about the nature of the claim being asserted by the trustee, that the trustee, even now, does not assert a claim that the shares in Eurasia are held on bare trust for him. He would need to be asserting that for it to be an interpleader, or a quasi-interpleader. It would need to be a claim in respect of the piece of property in the hands of the interpleading party, in respect of which other people are making a proprietary claim. Now that brings me on to the fifth point, which is Denax. Much reference is made to Denax to support the contention the Tomlin order envisaged that the trustee's claim would be adjudicated on in the Eurasia action, so supporting his contention that the Tomlin order envisaged the undertaking remaining in place until the trustee's claim, or for that matter, any third party's claim, which came to be asserted, has been finally determined. Now we suggest that reads far more into Denax than it bears. Now, at the risk of reminding my Lord Justice Snowden of matters he knows far better than I do, in Denax, a receiver appointed by way of equitable execution applied to the court for permission to proceed with the sale. Later on, the receiver was sued, it being contended he'd sold at too low a price. The receiver successfully applied to strike out the action as a Henderson and Henderson abuse. And in that context, my Lord made the point on which so much reliance is placed. But in our case, in the present case, the process of advertisement afforded an opportunity to third parties to come forward. If they did not do so and then sued Eurasia, Eurasia might, and I underscore might, by parity of reasoning with Denax, be able to say that their doing so was a Henderson and Henderson abuse. But that abuse argument doesn't depend on Eurasia being a trustee or anything like that. It simply depends on the third party having had the chance to come forward and having chosen not to do so. But it tells one nothing about whether the intention underpinning the Tomlin order was that the third party's claim would be decided in the erasure action, or more importantly, whether the undertaking was to remain in place until the third party's claim was decided. Now that, we suggest, is because there is a vast gulf between a trustee or receiver applying for directions about what he should do and a situation in which a third party comes forward asserting some kind of property claim in respect of the erasure shares, which is the kind of claim that may well be incapable of resolution without a trial. And now I suggest it's important to be clear about this. In our case, the question is not whether the replacement certificates should be delivered to Q&M solicitors, because they were. That would be a question about what erasure ought to do, which I suppose conceivably it might apply to the court for directions about. It was rather about whether the undertaking JHA gave should be released, which doesn't involve erasure in doing anything at all. The court's not giving directions to erasure. It's releasing an undertaking given to the court by JHA. Now that brings me to the sixth point, which is the relevant material for the purposes of construction. Now we suggest that an important error on the part of the trustee is to contend that the materials before the court for the trial of the erasure action, skeleton, witness statements and so forth, bear on the proper construction of the Tomlin order. Now we suggest that that's not correct. The Tomlin order provided for the making of an announcement in agreed form.
Sorry, I'm going to have to keep your voice up amongst others.
Forgive me, Lord.
Sorry, are you saying that the pleadings in the action which gave rise to the Tomlin order are not relevant?
The pleadings are relevant because they are accessible to a third party. You can get those from the court file. What are not relevant are the skeletons and the evidence.
Sorry, let me retreat for a second. We're talking about interpretation of the Tomlin order as between the parties to the Q&M against Eurasia case.
We are, my lord.
So we need to understand they were the background against which Q&M and Eurasia settled the terms of the Tomlin order.
Yes.
And so why is it relevant that they're available to a third party?
Because, my lord, they are not the only persons who might need to construe the Tomlin order. Might I just give my lord the headline and then develop this? That the headline works like this. This is a document addressed to third parties as much as it is to the parties themselves to the action. So third parties who come forward are going potentially to need to construe the Tomlin order to understand what it does. Those third parties will not have access to anything more than the pleadings. The pleadings they can obtain as of right from the court file, and indeed do so easily these days because it's all electronic. What they will not have any access to are the skeletons or the trial bundles. The action settled before it was called on for trial, and the documents in the trial bundles remain subject to the CPR 31 and 32 prohibition on collateral use and were not available for third parties. Now, as a matter of general principle, when one has an instrument that may need to be construed by third parties in this way, and court orders are in that category, one asks what the third party had access to. One asks what all the persons who might need to construe the instrument would have had access to or would have access to. And I'll develop that by reference to Cherry Tree, if I may. I don't know if my lords had a chance to look at Cherry Tree. It's if I might suggest, but it's a case with a lot of useful points about construction of instruments in this category. Now, if I can just develop that point. The Tomlin order provided for the making of an announcement in agreed form. We see that in Annex 1. That's core tab 10, page 165. And it might help just to turn that up so I can see what the third party would see. So it's core tab 10, page 165. And this was made, as we saw earlier, a few days later. It's an agreed form of announcement to be put out by Eurasia second paragraph refers to a compromise. The matter has been the subject of proceedings. The proceedings have been stayed by consent. Then the third paragraph, by consent between the parties, an order has been made. In accordance with the schedule to the order, replacement certificate will be issued, and so on. So it follows that the agreement embodied in the Tomlin order was not something only of interest to, by which I mean only might need to be construed by, the parties to the action. It was of interest to, that is, might need to be construed by, all the persons to whom this announcement was addressed. Because they, if they were going to come forward, would need to understand what this consent order did, what it provided for, how it affected them, what their rights under it were, what they ought to do, and so forth. And in that context, I do invite attention to Cherry Tree, which is in Authorities 2 at tab 26. Now, by way of introduction, Cherry Tree was a case about the construction of a registered charge. And the issue was whether the interpretation of that instrument, the charge registered at the land registry, was affected by a facility agreement which was part of the same commercial bargain, but which was not a document registered at the land registry, not a document therefore available to a third party. And Lord Justice Lewison, at paragraphs 124 and following, that's page 337 of the report, consider this question.
Sorry, page?
Page 337 of the report, on the top right, paragraph 124. It's 648 at the bottom, or 337 at the top. Authorities 2, tab 26.
Yeah, sorry, I was in the wrong one. 327.
337.
337.
This is Lord Justice Lewison's judgment.
Yeah.
And he returns then to the question of the relevance of the facility. And there's been a long discussion about the principles applicable. In paragraph 124, he discusses the Privy Council case in our pure ferries. That's about the grant of a license to operate a ferry service, where Lord Hope discusses the relevance of extraneous materials when construing a public document. That's particularly between letters B and C over the page, and then talking about a planning permission as well. That's the Slough Estates case. And then at 125, Lord Justice Lewison picks up on other instances where the role of background may be more limited. He says the same principle has been applied to the meaning of planning permissions, that's Slough Estates, and memorandums and articles of association, that's Egyptian Salt, and I underscore this, to the interpretation of an injunction or receivership order, that's Masry. In all these cases, the justification for the restrictive approach is that third parties might not will need to rely on the terms of the instrument under consideration without access to extraneous material. There's then a discussion of the position in Australia, and then at 128, there is an extract from a New South Wales case, which I do suggest is illuminating. And in particular, between letters E and F, Justice Beale Campbell says that because the reasonable person seeking to understand what the words convey would understand that the meaning of the words of the document does not change with time or with the identity of the person who happens to be seeking to understand the document. That reasonable person would therefore understand that the sort of background knowledge that is able to be used as an aid to construction has to be background knowledge that is accessible to all the people who it is reasonably foreseeable might, in the future, need to construe the document. So what I suggest the inquiry is as to is what background is accessible to all the people who might need to construe the order. That is to say, not merely the immediate parties to the Tomlin order, but the third parties to whom the announcement was to be made. Now, as for what's accessible to that person or that class of persons, I'd make the following points. That the case settled at trial, essentially, but before it started. Materials in the trial bundles remained subject to the prohibition on collateral use, and, like the skeletons, were not available to third parties. It's simply
I don't quite follow that. What? Why did you say that?
which bit, my lord?
In relation specifically to skeleton arguments. Skeleton arguments, there's been a lot of authority in recent years. Skeleton arguments are effectively now regarded as public documents. You've got to have a good reason, really, to say why they shouldn't be disclosed.
But nobody stood up and opened the action.
Say again?
Nobody stood up and opened the trial. It was not a case where the trial had started. It settled, as I understand it, before the case was actually, before
Yes.
the trial started.
Well, that's not uncommon.
Indeed, but those skeletons, whilst it might be possible for a third party to demand them, they're not accessible to that third party. They're not something the third party has or can get easily.
And you would distinguish, I think my lord's referring to Carpenter and other cases on open
Indeed.
justice, and you would say, well, the case never got there.
The case never got that far. But I contrast the pleadings, because the pleadings are accessible as of right to any third party. And these days there are commercial providers which make it very easy to get the pleadings. If you want the pleadings for an action that's on CE file, it's
So,
check a mouse.
to try and simplify, I mean, are you saying that you should only treat as part of the admissible background to interpretation those documents which you might reasonably expect a member of the public or an interested person to be able to access?
To have access to, precisely what?
That's
If that's the point. What one would not expect that person to do is to wade through the voluminous trial bundles in the hope of finding something that might somehow be relevant to the question of construction. The third party would have no access to the trial bundles. So, for example, the Sustrov statement, of which so much has been made, is something that a third party would have no access to.
So let me get this right. So you I'm sorry if I'm being slow, but you say this is a document that was intended to have, the Tomlin order was intended to have some impact upon third parties who might respond to the advertisement. Ergo, you don't interpret it in the normal way you'd interpret it by reference to the background material which was available to the two sets of parties who agreed the Tomlin order. You have to take a much more limited group of documents, namely those documents which would have been available to a reasonable third party who might have wanted to see the Tomlin order.
Exactly. I say it's not different from the situation considered in Masry, where one is considering, say, a receivership order.
So yes, it's highly relevant to this, isn't it? That this isn't just a Tomlin order that's inter partes settles an action. You rely heavily on the fact that third parties are per se involved. I mean, the Tomlin order doesn't say here's a confidential schedule, for example. It's setting in train a process that involves third parties.
Exactly.
So I don't think you're necessarily advancing your submission as applicable to all Tomlin orders.
Certainly not. No, certainly not. No, most Tomlin orders operate merely as a contractual settlement between the immediate parties. Third party interests are not affected, and the construction is a completely conventional one. But this is not unlike the situation of, for example, a negotiable document of some kind. For instance, suppose, to give an obvious example, my lord, of an issue of bonds. Suppose there were discussions between the issuer and the first group of bondholders about all sorts of things that would be background admissible on ordinary principles. The bonds are then sold in the market, and a third party comes forward and advances the construction about what the bond instrument means. One would say that all that to and fro between the issuer and the first batch of bondholders is neither here nor there, because it's always in the contemplation of the parties that the instrument is saleable, and the materials available to construe the bond offering, but the bond instrument do not extend beyond the instrument itself. It's an analogous kind of situation. There are plenty of other examples of a similar kind. Indeed, Lord Justice Lewison discusses quite a lot of them. So we say that the involvement...
Is there an example of a skeleton argument? I mean, I understand the submission in relation to the bundles, I understand that submission completely. At the moment, I'm struggling with the skeleton argument.
Well,
Point. Is that? I mean, obviously, Cherry Tree wasn't involved. That wasn't concerned with trial skeleton arguments.
No.
I mean, I understand the submission. There wasn't a trial, therefore, it's not a. You say, therefore, it's not a document that would be easily accessible by third parties. But to use your expression, therefore, for the background information, you have to wade through the chancery pleadings, not the crisp summaries that are in the skeletons.
Well, one might say that the pleading should not have been as diffuse as that. But that's a different point. What I would say is that the skeletons are not material reasonably accessible to
Yeah, I understand
the fugitive third party. Compare and contrast the pleadings because those are available as of right, and because it's all on CE file today, it's in fact at a practical level very easy to get.
But to bring it down to sort of the nuts and bolts, which things do you say that should not be, to which regard should not be had as a result of this proposition that you're putting forward, which otherwise is relied upon?
What my friend calls the undisclosed materials.
Sorry?
What my friend calls the undisclosed materials in his bundle. So perhaps the easiest way to do that is to look at the index to his bundle, and he defines in the bundle the undisclosed material as being the first statement of his
The appellant's bundle.
the appellant's bundle, and then just look at the index. Tab 3 is first statement of Mr. Sustrov. Then there's first defendant's erasure trial skeleton, and then there's the narrative of the first defendant erasure. It's those materials my friend relies on.
Tabs 3, 4 and 5.
Tabs 3, 4 and 5. It's those materials.
What's the key things that you're keen that we shouldn't place any reliance on, that Mr. Davies does place reliance on, or are you just making the point generally?
It's a general point. I actually say that none of these materials go anywhere
You
anyway.
don't want to identify the ones you're particularly keen that we shouldn't look at.
My lord, no. But what I do say is that they're not relevant in any way. They don't assist. That even if you look at them, it doesn't advance the position. And the reason I say that, and I'll develop that in a moment as well, is that the parameters of the erasure action were defined by the pleadings, and all this material does is evidence or further articulate points in play on the pleadings. Things were either in play on the pleadings or they weren't in play on the pleadings. And that actually the pleadings are what the erasure action was about, and that's what was being compromised.
The pleadings you accept could have been looked at.
Pleadings are very much accessible to a third party. Yes. As I say, that's because under the current regime, they are available as of right to a non-party once the defence has been filed.
And you draw attention to the fact that the announcement specifically gives the case reference number.
Exactly.
So
Exactly.
very easy.
If one hypothesises somebody coming to a firm of English solicitors and saying, I've received this announcement, what should I do? The first thing any competent solicitor is going to do, I suggest, is get the court file, or get as much of the court file as you can to discover what on earth it's all about. Now, that brings me to the next point, the seventh point, which is the way the Tomlin order works. My friend says that the Tomlin order...
This is number 7.
Point number 7, Lord, yes. The trustee contends that the Tomlin order contains what he calls dispute provisions. That's the trustee's skeleton at paragraph 4.
Can I just have one final push at this?
Lord, yes.
Just so I'm sure I'm not missing something. The pleadings are in, we've got the pleadings, right? As I
Yes.
understand it, in tabs 8 and 9,
Yes.
just before we get to the Tomlin order.
Yes, there's a reply as well. But yes.
Is there something which is not in there, which was in the skeleton argument, which we say, I mean, it's another way of putting the question which you declined to answer, but
I'm not sure whether the trustee says there's anything in the skeleton or the Sustrov statement that you can't get out of the pleading. I'm told he does. I'm not totally sure what that is.
The 31st of October ruling of the Russian court.
Well, I'm
just trying to focus this debate. Interesting though, this little digression into construction has been. I mean, I'm just trying to focus it on an actual point. And so this all is about what some. Sorry, I missed the aside. There's something which
apparently there's a ruling that you can't extract from the
Predates it.
that
The pleadings predate the ruling. The skeletons postdate the ruling.
Sorry, the ruling you're referring to is the one of the Russian court that we
Yes.
went to earlier from October 23.
Yes.
The one that says that Queeld is vested in the trustee.
And the pleadings predate that, and the skeletons postdate it.
In any event, the point I was driving at was what the erasure action was about, was what was on the pleadings. And what the effect of that Russian order was or wasn't something that was going to be tried out or determined in the erasure action. That was simply not what that action was about. And that brings me on to the seventh point, which is the way the Tomlin order works, and the suggestion that the Tomlin order contains what are called dispute provisions. Now, the suggestion there is the suggestion in the grounds of appeal, which is that the Tomlin order contains within itself provisions for resolving a dispute. And the short point we suggest is the Tomlin order does not contain dispute provisions understood in that sense. It envisages third parties coming forward. It envisages the court having to decide how to proceed in relation to the undertaking if they do so. But what it does not do is provide how procedurally any such claim is to be adjudicated upon. The drafting of the order itself, that's the substantive part of the order, and the schedules do not make such provision. And we suggest that's unsurprising for three linked reasons. One, what a third-party claim would look like was unknown at the time the Tomlin order was agreed. Whilst there may have been people who may be likely to come forward, it was unknowable who would in the event come forward. It would therefore not have been sensible to make a provision which sought to determine how unknowable claims should be addressed. Second, all that the body of the order actually does is stay the action. If the intention had been to reconstitute the erasure action as the vehicle for resolution of third-party claims, potentially involving disclosure and a trial, the court would have needed to have been told about that, and the order would have needed to make provision for it. And it doesn't. It's my Lord Justice Snowden's point that we couldn't, by the schedule to the Tomlin order, dictate to the court how the court ought to allow its resources to be allocated. And third, we suggest it's not possible to extract any kind of contractual intention or agreement to that effect from the schedule. Now, finally, under this introductory heading...
So, I mean, to give an example, I mean, I've certainly seen in the past a Tomlin order that purported to resolve one dispute between the parties, and then indicate that if some problem arose in the working out of the Tomlin order, that the court would resolve the dispute between the parties in a way that didn't actually correspond to any cause of action or jurisdiction that the court would have in the ordinary way. I mean, I'm just struggling to remember what it was now, but it was something along the lines of, if the parties can't agree, the court shall fix a fair payment from one to the other. In other words, act as some sort of quasi-mediator arbitrator in a way that the court wouldn't ordinarily have jurisdiction to do. Your point is that if you're going to sort of foist such a thing on the court, you can't do so just by contractual. You can't confer jurisdiction on the court just by contract.
Exactly.
You at the very least you've got to check with the judge that that's something the court is actually able to do.
Not quite so. And the Tomlin order contains no suggestion that that's what was intended to be done. Now, finally, under this heading, there's a point about what the heading of preliminary points, about what the claim being advanced now in relation to the erasure shares is. And as currently formulated, it's simply that the ultimate beneficial owner of Q&M is the trustee. Now, I do just invite attention at this point to the ways of protecting such a claim in principle available. So the first way would be to say that the shares themselves are held on trust for the estate and to apply for... I'm sorry,
You mean the erasure?
I mean the erasure shares. to say that the erasure shares themselves are held on bare trust, that the trustee can therefore demand a conveyance of the shares under the rule of Saunders and Vautier, and on that basis assert a proprietary claim and seek a proprietary injunction. That's possibility one.
This is on the basis that it's said that the shares in Eurasia are beneficially owned.
Exactly. That's possibility one, is to assert that. That's not the claim being advanced against me.
That isn't the claim.
So that possibility is out. So then one is on to two other possibilities. The first of those is to apply for a freezing injunction and extend it to the erasure shares pursuant to the chamber jurisdiction. That involves bringing a claim in England of some sort and saying that the chamber jurisdiction entitles you to an injunction freezing the erasure shares. I'm just outlining the possibilities here, my lord. I'm not saying any of these have any legal merit. And the third possibility is to sue somewhere else, Cyprus or the British Virgin Islands, for something, come to England and ask for a freezing injunction under the Civil Jurisdiction and Judgments Act in aid of the proceedings abroad. Now, those are the possibilities. Now, what's being said here is that in circumstances where there is no claim here that the shares are beneficial of the property of the estate, there is no claim elsewhere seeking to cut into the corporate structure above by saying that the shares in Q&M have vested in the estate. Those proceedings have not been brought in Cyprus and they've not been brought in the British Virgin Islands. What is said is that nevertheless...
So what? So I'm not. This isn't a complaint. In many ways, it's admirable you make your submissions in such a sort of pithy way. But I'm just trying to unpick slowly what you've just said. Why would you bring claims in Cyprus or the British Virgin Islands in relation to claims to the shares in Eurasia?
Because if you're the trustee, you bring a claim there to be registered as the proprietor of the shares, of the shares in Q&M.
Okay, that's
and you say that action is going to take years to come on to trial. So what I want to do is apply in England for a freezing injunction in aid of my proceedings in Cyprus or the BVI, so that the shares at the bottom don't vanish before I can get my action in the BVI or Cyprus onto trial.
Yes, it may be that I just misheard your previous, the way you put it. You would only be in those circumstances bringing an application for an injunction in England in aid of the foreign proceedings. But the foreign proceedings would be aimed at establishing your ownership or control of Q&M.
Indeed.
Or Q or M.
Q or M or both. Exactly, depending on which jurisdiction. But here, there are no proceedings in England asserting a proprietary claim still to the erasure shares. This court doesn't have jurisdiction to try the question who owns the shares in Q&M. Those shares are not property in the jurisdiction. And there are no proceedings in the place that would have jurisdiction. And what is said by the trustee is, notwithstanding all of that, the undertaking is to remain in place until the end of this nebulous claim now being brought forward is brought to a conclusion.
Okay, again, rewind. You say this court has no jurisdiction to resolve a dispute as to ownership of shares in a Cypriot company.
Well, let's just unpack that.
As a general proposition, that can't be right.
Well, it depends how you found jurisdiction. So that the shareholders in Q&M are not said to be amenable to the jurisdiction of the court. That the piece of property, the intangible consisting of those shares, is not in England. So you can't get through Gateway 11 in respect of those shares. We will get onto this on the respondent status on the other appeal tomorrow. But the shares in Q&M, that intangible, is not within the jurisdiction. The shareholders are not within the jurisdiction. The shareholders have not by contract submitted to the jurisdiction, and there is no other available gateway to bring them before the court. So there is no way of suing the people who own that piece of property in England. Forgive me for not unpacking that, my lord.
So, if the claim were pure and simple we own the shares in I trustee own the shares in Q&M.
Q&M.
And that was the claim the trustee was bringing. They wouldn't be able to bring that claim in this jurisdiction.
Q&M wouldn't be the defendant in the first place,
Well,
because the
indeed.
property isn't property they own. And I suppose you might join them to the
but
action.
there's
but
no, you'd say there's no basis to serve out.
there's no basis for granting leave to serve out, because the only basis for granting leave to serve out is Gateway 11. Gateway 11 is property within the jurisdiction. Again, at the risk of getting into things that are relevant on the respondent's notice, if I can just give the headlines. The intangible consisting of those shares is as a matter of English private international law cited at the place of incorporation, BVI in Cyprus. Gateway 11 requires a claim in relation to property within the jurisdiction. You therefore cannot get through Gateway 11 by asserting a claim to a shareholding in a company incorporated abroad. You might be able to get there by some other route, personal service, contractual submission to the jurisdiction, some other ground.
So, where are the pleadings that are currently being filed in the, that we saw this morning? Sorry, I've lost them in the bundle.
They're in the respondents bundle, my lord. And the way that they are, the defence respondents bundle, tab 3, page 110, and reply at page 132.
Right, so the defence is filed by Mr. Vesnin, in fact,
Yes.
and they want trial.
Well, the oddity of this is the trustee was given permission to file a counterclaim. And for our part, we expected to see a counterclaim that said the shares are held on bare trust. We're therefore asserting a proprietary claim.
The Eurasia shares.
The Eurasia shares,
Which it doesn't say.
which it doesn't say. What it says is at the end, conclusion on page 130, in the premises, the court should not direct the delivery of the replacement certificates. I'm sorry, the court should direct the delivery of the replacement certificates to Mr. Vesnin, not to the claimants for the ultimate benefit of the de facto UBOs. But that's a conclusion asserted without saying that the shares are held on bare trust.
Somewhere here, you've presumably pleaded that there's no jurisdiction to try this dispute.
Well, we said a lot of introductory things in paragraph 2 of our pleading on page 133.
Are you saying that there's no are you saying that there's no are you disputing that there's jurisdiction to try the dispute as pleaded?
There is jurisdiction in respect of that because the piece of property in question, the Eurasia shares, is property within the jurisdiction.
But I thought your point was it's not a claim to the Eurasia shares.
It's not.
So-
It's not as constituted.
Because as currently constituted, this is not a claim to the shares in Eurasia. This is just don't give them the share certificates because they might do something wrong with them.
Exactly.
So is the jurisdiction for this the pieces of paper, the share certificates are within the jurisdiction of?
The pieces of paper are within the jurisdiction, and the Eurasia shares themselves are cited within the jurisdiction. And we of course submitted to the jurisdiction by suing you.
But not for, well, I thought your first point was not for this type of dispute.
But not for a dispute about who owns. This is the respondent's notice on the other appeal. Well, when we get into this, but we Q&M do not own the shares in ourselves, obviously, and we say there's no jurisdiction to try a case about who owns those shares. And anyway, the people who are the right defendants to that action haven't been joined. This point, though, is focusing on what the trustee is asking the court to do in respect to the undertaking in circumstances where he's not actually bringing forward a claim at all. The shares themselves, the Eurasia shares, are vested in the estate, but this decidedly amorphous, nebulous case about ultimate beneficial ownership. Now,
What's the answer to my lord's question? Is this point pleaded? I don't obviously see it in paragraph 2 of the reply.
Which point, my lord?
The jurisdiction point. You're effectively what is covered by the submissions you've been making under point 8. About the different ways it could have been done, but you say not here.
We say all those things haven't been done. We don't say there's no jurisdiction in the sense that the court should accede to a CPR 11 application because, of course, it's a defence. It's pleaded purely as a defence, not a counterclaim. Now, if it had been pleaded as a counterclaim, we might have an argument about how CPR 11 works.
Sorry, I thought your thrust of your submission so far was we Q&M submitted to the jurisdiction because we sued Eurasia for one purpose, which was to have delivery of the share certificates, and there was a dispute about whether it was an appropriate exercise of discretion by the directors of Eurasia to decline to issue the share certificates other than on certain indemnities. That's the dispute we submitted to the jurisdiction for. We resolved that by a Tomlin order. That cause of action fell away. What you can't do is then use that as a vehicle for a completely new and different dispute, which relates to the ownership of the shares in Eurasia, brackets, which it doesn't.
Or at least that was not something contemplated by the parties at the time of entering into the Tomlin order, which is what matters.
Yeah, or certainly not for the claims that are in here, which are some of the claim. And your point is, who knew what claims were
Exactly.
coming out of the woodwork as a result of the advertisement, and that the Tomlin order couldn't be the vehicle for resolution of any and all claims that might come out of the woodwork of any description to the share certificates in Eurasia.
Not exactly.
In a sense, for purposes of today's appeal, you don't need to go beyond that point.
No, I don't. Now that brings me to ground one, if I may, which gives rise to what I suggest is an exceedingly short point. What did Mr. Justice Adam Johnson decide in a couple of paragraphs of note? That there are two competing contentions. There is the trustee's case, which is that Mr. Justice Adam Johnson decided that the Tomlin order means that once a third party comes forward with a claim capable of being protected by the undertaking, then the undertaking must remain in force until that claim is finally adjudicated upon. On the other hand, Q&M's case, which is that all that was decided was that the claims advanced by NBT and the trustee were capable of being protected by the undertaking, so it shouldn't be released then and there, but instead there should be a hearing at which they had a proper opportunity to put forward their case and to participate, at which the court would decide what to do, which might involve leaving the undertaking in place, and it might not. That would all depend on how matters stood once they'd crystallised. Now I suggest that construction, the second construction, is correct for a series of what might be called positive and negative reasons. And negative reasons being the things that Mr. Justice Adam Johnson didn't say in his judgment or provide for in his order, which he would have done if he'd decided the way that the trustee says he did. Now, to put this in some kind of context, I invite focus on where matters had reached by the 13th of March 2024, when matters were before Mr. Justice Adam Johnson in the interim applications list. By that point, the trustee had formulated matters only in correspondence. He hadn't engaged English lawyers. It was far from clear that he would engage at all, or, if he did engage, precisely what the English solicitors he instructed would advance by way of a case. NBT had only very shortly before the hearing instructed English solicitors, and his counsel, also instructed at the last minute, was in no position to do anything more than ask for an adjournment.
It was all at the last moment because you'd applied the very first day you could, and you got it into the applications list where it plainly shouldn't have been.
Well, Lord, that's certainly one.
So I mean, this is the background to the judgment of the 13th of March, but we're not construing a statute.
My Lord, what I'm going to suggest is that Mr. Justice Adam Johnson, doubtless hard-pressed in the applications court, decided no more than he needed to based on the contentions before him at that point in time. And that what he needed to decide was limited, and he didn't go beyond that. Now, turning to...
Since there's a transcript of the hearing, could I say, A, that the note of the judgment is admirably clear and therefore a credit to Simmons and Simmons, and the judgment itself is also admirably clear and a tribute to Mr. Justice Adam Johnson.
Lord, yes. Now, it's necessary to be clear, I suggest, as to what the contentions were. Q&M's case was set out in Duncan 4, that's supplementary tab 15, and its skeleton argument, that's supplementary tab 17. In the interest of time, I'm not going to go through those. But to summarise, what Q&M argued was that for the protections of the undertaking to avail a third party, that third party must be asserting a claim to or interest in the replacement shares certificates in the form of a claim to current ownership or to an asserted current legal or equitable interest. That's in the skeleton paragraphs 8 and 21. So that's pages 256, 262. And the argument being put up was that because neither NBT nor the trustee was asserting such a claim, the undertaking should be released. What NBT was saying...
Can you just give the reference again?
Yes, it's perhaps more probably can turn them up. It's supplementary 1, tab 17. And this is the skeleton of Q&M for the hearing. The supplementary 1, tab 17. And if I can invite attention to page supplementary 1, tab 17. Supplementary 1, tab 17, and then at the bottom of page 256, we have a description of the way the Tomlin order worked. And then at 257, a couple of inches down, it said essentially the intention was there would be a period of 4 months in which any third parties could assert any claim to or interest in the shares. Then on 262, paragraph 21, about halfway down, there's a construction point. The reference in the announcement to a claim or interest is plainly a reference to a claim to current ownership or to an asserted current legal or equitable interest. Taken at the highest, neither Mr. Vesnin's letter nor NBT's letter assert any such claim to or interest in shares. And then the conclusion is in paragraph 25 on page 263. In circumstances where no third party has asserted any claim to or interest in the shares in the relevant sense, there is no basis for the releasement of the replacement certificates to be delayed any further. So that was Q&M's case.
It was the wrong kind of
It
claim,
was the wrong kind of claim.
which Mr. Justice Adam Johnson rejected.
He rejected that contention. NBT was simply seeking an adjournment. One sees that in the notes of paragraph 3.2. They weren't in a position to say any more than that. Eurasia took a neutral stance. And I do suggest it's against that backdrop the judgment falls to be considered. What was being said to the judge is the claims do not engage the protection of the undertaking at all, and therefore it should be released. Now, again, I don't propose to go through the judgment. We've been through it already, but I do invite attention to what I suggest are 5 key points. First of all, that the core is in paragraph 6.7 of the note. That's supplementary tab 7, page 80, and in particular the final sentence. And we suggest in that short passage, the judge resolves the point before the court. It doesn't go beyond that. The judge's view was that the court, once a claim was advanced which was capable of being protected, should, and I quote, give further directions as appropriate. But what might be appropriate is not something the judge was invited to or needed to decide that day. Once he dismissed the in limine objection on the part of Q&M, that was an end of what needed to be decided that day. Second, all that was decided was that the undertaking was capable of being protecting claims of the kind being advanced. That's my Lord's point a moment ago. Third, the judge did not go on and say the undertaking must remain in force until those claims were finally decided. Fourth, the judge regarded the effect of his decision as being effectively the same, those are his words, as if he'd granted the adjournment sought by NBT. That's paragraph 6.12. In other words, the question about what the court should do was deferred, it would not have been apposite to regard this as achieving the same thing as standing over the application if what the judge had been deciding was that the undertaking should remain in place until final resolution of the claim or claims of NBT and trustee. That's totally different from him simply standing over the application to another day. Fifth, and following on from those points, what was envisaged was a further hearing with NBT and the trustee able to participate if they wished, at which the court would decide what further directions were appropriate as matters then stood. Now, turning around to what the order does and doesn't do. The question, who is the true UBO, or any question framed along those lines, is one which at least potentially gives rise to serious disputes of fact, including about the basis on which the shareholdings of QNM were held, about whether the Russian bankruptcy is entitled to recognition, and potentially in respect of the NBT's asserted claim, all manner of other complicated questions. Final resolution of those questions is never likely to be straightforward. I do rely on Coyne, referred to in my skeleton, for support for the obvious proposition the court doesn't resolve disputed questions of fact on affidavit evidence. And if what had been envisaged was a determination of whatever the factual issues that emerged were, once NBT and the trustee actually articulated their positions, the directions couldn't possibly have looked like this. Instead, what the order does is something very different, and if I can invite attention back to it and to the way it works, it's Supplementary 1, tab 9. And as my friend explained earlier, it defines the issue as being whether the undertaking should be released. It's not defined as being a question the trustee says needs to be resolved. Indeed, given that the trustee wasn't represented, NBT had only just instructed an English legal team, it would have been premature to define any kind of issue in that way, because there was no way of knowing what those claim or claims would actually look like once articulated. Second, what it refers to in paragraphs 1 and 5 is a renewed application to release the undertaking or for directions. And one sees that in the middle of paragraph 5 in the context of a renewed application by the claimants for the undertaking to be released and or for directions pursuant to the provisions of the Tomlin order. And there's no suggestion in there that the undertaking should remain in place until final resolution of the claim or claims as they came to be asserted. But the drafting of this simply leaves the question of what the court should do, the hearing to be fixed pursuant to paragraph 9 at large. Thirdly, paragraphs 7 to 9 provide for a compressed timetable for the service of evidence leading to a 2-day hearing. And we suggest those are simply not directions appropriate to decide disputed questions of fact.
What's going to take 2 days, though, if that is right?
Well,
If you're right, and this isn't envisaging any sort of contested hearing, and I understand that submission, what on earth were you going to be doing for 2 days?
well, I wasn't involved in the drafting of this order,
I follow that.
but I'd
You're relying on you're relying on this in a sense for a negative reason to say, well, it would have been even longer if we'd had contested hearings. But I have to say 2 days strikes me as inordinately long if it's just dealing with really quite a narrow point.
Well, it's certainly possible to envisage a world in which people brought forward claims and we said, well, those don't give rise to properly arguable claims at all. And we have what was essentially a summary judgment application. Those kind of questions is what is being...
expert evidence?
It's not totally clear to me what was actually envisaged by that.
May not be totally clear, but does that mean I have no idea?
I wouldn't want to speculate as to what was in the minds of those who drafted the order. Russian law, presumably, is the most likely target. But but it doesn't, I mean, rather unsatisfactorily, the order doesn't define the issue on which expert evidence is to be admitted.
Well, it's evidence upon which they will rely in relation to the issue, including any expert evidence. I mean, it's presumably, say, in some way it might have been thought that Russian law evidence was required in relation to the question of whether the undertaking should be released. But anyway, okay, it's not your case. No part of your case to identify what that might have been.
No. It's certainly possible that there would have been a contention that the claim brought forward didn't give rise to a tribal issue. Those kind of issues might easily have occupied quite a lot of court time. Now, the fourth point is that the order as a whole envisaged the parties setting out their positions, with the court free when the matter came back to decide whatever seemed appropriate in light of matters as they then seemed. And we suggest that's what the order does. In conclusion, Mr. Justice Adam Johnson wasn't asked to decide whether the Tomlin order envisaged the undertaking remaining in place until final determination of third-party claims. That just wasn't out there as a contention before him. He didn't need to decide that question in order to deal with the matters before him, as I say, in a doubtless busy list with other people wanting to have their urgent applications heard, and he didn't decide it. That's the end of ground one. Ground two is the question of proper construction of the Tomlin order. There are two competing constructions. Construction one, the trustees, if a qualifying communication is received such that automatic release does not occur, the undertaking is to remain in place until that asserted claim, whatever it is finally resolved. And our construction, the judge's construction, which may be summarised as being that if automatic release does not occur and one or other party applies to the court, it's then for the court to decide how to proceed. And we say that there are three stages, albeit connected, embedded in the Tomlin order. Stage one, which arises from paragraphs 2 and 5, is whether either party has received any communication in relation to the subject matter of the announcement. If there has been such a communication, then there's no automatic release. But that's a very low bar indeed. All it requires is receipt of, quotes, any communication in relation to the subject matter of the announcement. It doesn't matter what kind of communication, no kind of filter, doubtless, because that would have just led to further argument. It's simply a narrow question: has there been receipt of any such communication? If such a communication is received, that takes you to what I call stage 2A, which is to ask whether the communication in question asserts a claim capable of being protected by the undertaking. If there is no such claim, then the undertaking is no longer needed and should be released. Now, that question arose before Mr. Justice Adam Johnson because Q&M said what was being said by NBT and the trustee was not capable of being protected, but often it will be rolled up with the next stage, which I call stage 2B, which is what the court should do in light of the claims being advanced, assuming they are capable of being protected by the undertaking. The drafting of the order, we suggest, does not prejudge that question. It's left entirely in the hands of the court, and it's left entirely in the hands of the court for two good reasons. First, it was unknowable, as I said earlier, at the time of contracting what claim or claims might in the event be put forward. And second, this was a compromise of a long-running dispute. Objectively, the parties did not wish to extend that dispute by attempting to agree precisely what should happen. Their compromise was to leave matters in the hands of the court. We say on the language of the schedule, there is nothing to indicate the undertaking should remain in place until final resolution of any claim. And the arguments the trustee brings forward do not begin to displace the construction we say follows from the language and is supported by the context. Now, just picking up the context points briefly. First, the Tomlin order envisages a comparatively expeditious process, with the parties free to apply to the court. And there is nothing to show the parties intended or contemplated a lengthy process with the undertaking remaining in place perhaps for months, if not years, whilst issues were tried. Second, The Tomlin order was intended to bring the dispute to an end. It wasn't intended to leave matters hanging for months, potentially years. Third, it's relevant to ask, I suggest, how a third party who asserted a claim could have been expected to behave. Such a third party would, if faced with the Tomlin order, see considerable scope for argument about whether his position, its position, could be properly protected by saying the undertaking should be continued. And that third party might very well, therefore, simply issue a fresh claim and apply for an injunction. After all, the third party who said the shares had been sold to him, they were mentioned in the pleading, might simply issue a claim, say they're my shares, or bring forward a claim for specific performance, and seek an injunction to protect that pending trial. And in that situation, the undertaking would not be needed. Of course, the third party would have to give a cross-undertaking in damages, and that would be a strong discretionary reason, I would suggest, if he appeared in the undertaking proceedings, hadn't issued proceedings, and wanted what was effectively an injunction to not continue the undertaking. Fourthly, and this is a linked point, if the intention were to leave the undertaking in place until final resolution, that gives the third party in substance the benefit of an injunction, but without providing a cross-undertaking. That involves saying that when matters come back before the court on an application to release the undertaking, the expectation was that the court would freeze the erasure shares without reference to the conventional test for an injunction and without requiring the provision of a cross-undertaking. And we suggest it's inherently unlikely that it was envisaged that the court would proceed in that way, given the very well-established approach of the court to applications for injunctions. Now, turning then to the Russian trustees' argument, these are largely focused on his position, but I suggest that's not the right inquiry. The inquiry is what happens if a third party comes forward, not what happens if this particular third party comes forward. I'm not going to repeat all the points in section E.5 about skeleton, but I continue to rely on them. But drawing those threads together, we say that the Tomlin order does not, as a matter of language, construed against the relevant background, yield the result for which the Russian trustee contends. And that's ground 2. Ground 3 is the procedural fairness argument about which very little is said. It does not, as an independent ground, go anywhere. Its purpose, its only purpose, is to enable the trustee to say that the materials not before the judge should now be considered. Now, that means the materials I identified earlier. It's the appellant's bundle, tabs 3 to 5. It doesn't assist with ground 1. Ground 1 is either right or wrong. That depends solely on what Mr. Justice Adam Johnson decided. And on ground 2, it only matters if the materials in question actually affect the outcome, if they actually bear properly on the construction question. I've outlined the circumstances in which these materials were available to the trustee at a very early point. In those circumstances, I suggest there has been no unfairness procedurally to the trustee. I'm not going to repeat all the points in my skeleton where the chronology is set out. But I do underscore this point. This only matters, it only affects the outcome if these materials actually bear decisively on the proper construction of the Tomlin order. And I say that they don't and they can't, because the point we're arguing about is whether the undertaking should remain in place pending final resolution of any claims or not. And all these points, which just go to precisely what kind of claims were known at the point of the compromise, don't assist in resolving that question. To say that this third party or that third party or the other third party was out there and bringing forward this kind of claim or that kind of claim doesn't help, doesn't bear on the question of when the parties intended the undertaking should come to an end. And for that simple reason, I suggest that's an end of ground 3. It doesn't go anywhere. Unless there are other points on which I can be of assistance.
No, thank you very much. Yes, Mr. Davis.
May I take one specific submission out of turn in terms of the order in which they were made by my only friend, and turn to the point he had on what I might call the cherry tree point. This is this idea that one can only look at publicly available material in order to decide what the relevant circumstantial material is for the purposes of construing the Tomlin order. 3 points, if I may. The first is that, of course, in a case like this, that would lead to quite absurd results. You might have two skeleton arguments where each of the parties is addressing the judge as to precisely why it is that they're entering into this Tomlin order and explaining its purpose and why it's a joint approach and so on and so forth. And the suggestion that that material is not available to the court when deciding what the purpose and meaning and effect of the Tomlin order is counterintuitive to the point where it's perverse. And it is often the case, especially in more complex cases, that skeleton arguments are submitted for the purposes of persuading courts to bless a Tomlin order where there's a complicated schedule. Secondly, this is a case where, in fact, the parties were sent links to the documents, the 3 documents that are referred to as the undisclosed material, including the Eurasia's trial skeleton, prior to the hearing in any event. In other words, on a case such as this, any third party coming forward would get hold of the skeleton argument on request. And that's what happened in this case, in the sense that the link was sent to Mr. Vesnin, who sadly is a Russian speaker and was a litigant in person at the time. But the idea that in some way the documents are in purdah in a case where the court has made an order directing an advertisement to bring people in, anyone who asks for the skeleton, of course, can see it. And the third point is that the facts of this case demonstrate that the pleadings, which are said to be the only available material, were substantially out of date in terms of the relevant events, which would be in the minds of the parties when they entered into the Tomlin order. And I mentioned, in particular, the Russian ruling of October 2023, which postdated the pleadings, but played a significant role in the minds of the parties when entering into the Tomlin order, not least because Queeld and its legal representatives had been fighting the trustee in Russia in the litigation concerning the shares in Queeld. That for their part, Eurasia had been made aware of that and, of course, could see that the trustee, having gone to the trouble of getting an order in Russia, was hardly likely to lay down his tools and go home when he heard that, in fact, the certificates in London were about to be released to Queeld and Meisber. So I would strongly suggest that the cherry tree doctrine, Lord Justice Lewison dealing with publicly available documents, does not apply to a Tomlin order, even in circumstances where the Tomlin order involves an advertisement to bring in potential challenges. The next discrete point, and again, in order of how we perceive their importance, which is why I'm dealing with them in this order, relates to what was said about our client's defence, which appears in the respondent's notice bundle, and you were taken to that. Could I just make, again, 3 points about this defence? The first is that it does precisely what the Tomlin order envisaged in 3 different respects. First, it voices an objection to the release of the certificates. it is a defence on that basis. The court invited people to come and voice their concerns about a proposed release of the certificates, and that is precisely what the defence says, and no more. Secondly, it is a defence by a person who was directly in the contemplation of the parties when they entered into the Tomlin order.
So you say that the defence voices concerns about release of the undertaking.
It says, do not do it.
Well, that's what I just want to probe for a second. I mean, surely if it was just a question of voicing concerns, you don't need pleadings, you don't need to do anything else. Somebody just voices a concern. I mean, you've got to
It pleads a case for not releasing the certificates to Queeld and Weisberg.
My note, Mr. Davis, as you said, it voices objection to the release of the certificates.
Yes, I'm sorry.
In fact, it goes further and says release them to the trustee.
It says that it reserves the right to seek assistance in that respect. But of course...
Well, the last paragraph asks for it to be transferred to the trustee. Paragraph 49 from recollection.
Yes, direct delivery of the placement certificate, quite right, to Mr. Vesnin. And that is on...
So as my lady says, it does rather go further than voicing an objection.
Yes, but that is precisely what was within the purview and contemplation of those settling the Tomlin order. That people would come forward and say, do not release the certificates to Queeld and Meister, release them either not at all or to me. There's no other way of reading the Tomlin order, or indeed, if I may say, and this is my third point, the order of Mr. Justice Adam Johnson, because that order, as we saw in its recitals, defined the issue as whether the undertaking should be released. And we have come forward to the effect that it should not, insofar as delivery should not take place to Queeld and Meister, and we recognise that we may need assistance in relation to further protection, but that's another matter. The reality is this is a defence precisely as envisaged by the Tomlin order and by the order of Mr. Justice Adam Johnson on the 13th of March of last year. And my learned friend's submissions to the effect that in some way we're doing something without jurisdiction, may I perhaps state the obvious, which is that if my learned friend considers that this defence should be struck out, or that in some way it is susceptible to reverse summary judgment, he can make those applications. These pleadings were directed by the court. They have been served and filed. There is a case management conference probably to be listed in May, possibly June. And he can take his course if he considers that there's something that's not seriously arguable, whatever the test is, in this pleading.
I haven't tracked back to the order of ICC Judge Briggs for directions.
I think it's the one at tab 13 in the supplemental bundle at 221. And
so he says the restrictions are removed such that the third defendant may participate fully in the proceedings, including by advancing, so fully participate in these proceedings. Now at that stage, I'm not quite sure what that means. But
my lord, it's removing the restriction. You may recall on paragraph 6 of the judgment in relation to the access to documents.
This was Adam Johnson's order. That
It was.
Joined as parties for limited purposes.
Yes.
Exactly.
So removing that.
Yes.
right, so the proceedings in which you are going to participate fully are the original proceedings commenced by M&Q.
Yes. So we were, as my lady has said, that we were joined for limited purposes originally, and he's removed those restrictions.
And so you said including by advancing such claims or claims as may be advised in relation to beneficial ownership of shares in Eurasia, which you haven't done.
And we've made it clear that we
So-
are going to await disclosure in that respect.
Well, you just, okay, but you haven't done. But you say you are participating fully in the proceedings by advancing a different claim, namely that because you have a right to the shares, you say, in Q, but haven't got control of Q, you don't want the share certificates given to the people who are currently in de facto control of Q.
Exactly so, and the Tomlin order does envisage people simply objecting to the release of the certificates to Q&M. That's the, in a sense, the object of the exercise. We've not gone outside of what was contemplated by the Tomlin.
But paragraph 47, I'm just looking at the pleading, paragraph 47, the one we were talking about, paragraph page 127, 128 of your bundle.
Yeah.
What bits of that are you saying that the English court can resolve?
All of it. It can make findings of fact in respect of all of those matters.
You say the de facto UBOs, by which you mean
Mr. and Mrs. Mr. Ananiev and Mrs. Ananieva.
are they defined somewhere?
They are. Paragraph 4, I think it is.
Oh, yeah. Right, so you say that you want the English court to resolve the question as to whether Mr. and Mrs. Ananiev wrongly control two companies based in British Virgin Islands and Cyprus.
Yes.
How?
But in the ordinary way. I mean, there will have to be, that's what was envisaged by the order of Mr. Justice Adam Johnson. It was made clear, I think, in the note of his judgment that it was expected there would be, for the purpose of NPT's claim, expert evidence of foreign law to assist the court in the usual way, insofar as necessary. And the reason the dispute is here is because the share certificates are here and they've been issued on subject to the terms and conditions of the Tomlin order. And that gives the court the jurisdiction to decide this dispute.
What? But in the absence of the de facto UBOs themselves, they're not parties.
They're not.
But you say that the court, just looking at what you say, your case is in paragraph 47.
Yes.
How did these proceedings in England enable resolution of that case?
Mr. Ananiev is bankrupt, and at the moment we are recognised in this jurisdiction as his bankruptcy trustee. Mrs. Ananiev is also bankrupt, and the effect of Russian law is
She's
that...
not. She? I didn't think so.
Yes.
I haven't.
Yes, she is.
Okay. It's not what. Okay.
Yes, she is.
Can you give us a reference to that?
Certainly, we'll find that. I think it's...
I understood Mr. was, and it was said that Mrs. assets belong to his estate. But I've never heard reference to Mrs. being bankrupt or her trustee.
Yes, it was, we can find it, we set out the details, I think, in the skeleton argument for Mr. Morgan.
Okay, but, all right.
And indeed for Chief Judge Briggs.
So
I can't, I'm afraid, remember the dates, though, but
So you'd have to
it was much more recently.
You'd have to join either her or her trustee in bankruptcy.
It will certainly involve her trustee in bankruptcy once we've got over the recognition issues. We didn't want to do that until we've finally decided,
But in any event, the fact
decided
that-
whether we have been recognised.
Right, but the fact that you're Mr. Aliev's trustee in bankruptcy as far as the Russian court is concerned, that wouldn't enable you to have resolved the question of whether he wrongly continues to control both companies, would it?
That we have put him on formally on notice, and he is there is evidence that he is aware of the recognition proceedings, and he has decided not to contest those. He is aware of these proceedings, and he has decided not to contest. We can't serve him out of the jurisdiction, but that's he has notice of them, and it's a matter for him whether he wants to come forward. We can't serve him. I'm told that it's, if we look at supplemental bundle, tab 23, page 335. That's paragraph 7, I think. That simply gives the date of the bankruptcy order as the 5th of July 24. But I'm confident that I've seen that bankruptcy order and indeed, as it were, the build-up to it, and I don't think it's controversial factually. It's also a publicly available document.
So there might be a dispute between her bankruptcy trustee and Mr's bankruptcy trustee as to who owned the shares in.
They're both subject to the joint estate rules of the Russian bankruptcy legislation. So it would only be a matter of potentially amounts rather than the principle. There are rules apparently as to which estate comes first in time and priorities of that nature.
Yeah, but that may be so, but the question of who the shares belong to,
Yes,
whether they belong to her estate or his estate,
yes.
is a prior question. Anyway, but you, I'm struggling at the moment to understand how your case, as set out in paragraph 47, is actually going to be resolved in these proceedings.
Well, we intend to establish those facts. And we would hope to do that once we've got disclosure, because of course we've seen in the undisclosed material now, the disclosure as summarised by my learned friend Mr. Harrison, his skeleton argument and his narratives documents. And it looks overwhelmingly useful to the trustee to establish the propositions which are set out in paragraph 47. It was the undisclosed material which opened our eyes to quite how much material there is, because none of it has been disclosed to the trustee. And so when Chief Judge Briggs enabled us by his direction to participate fully in the proceedings, that means that all other things being equal, we will be able to proceed to disclosure. And that exercise has already taken place as between Q&M on the one hand and Eurasia on the other. And we would want to now have disclosure of those documents. But I would, at the risk of wearying you with repetition, I mean, these are all matters which were in the contemplation of the party, parties when they entered into the Tomlin order. Necessarily so. Mr. Vesnin, whatever my learned friend says, had just acquired his ruling in Russia in respect of the shares in Queeld, and everybody knew full well that he was not going to just lie down and tear that order up. He was going to come to the UK if somebody told him about the English proceedings. And eventually he was told by Simmons and Simmons.
Okay, so that's the defence, which was your second point, I think, in reply.
Can I also just make it, getting back now to the beginning of Melanie Friend's submissions, could I ask you to make a note in the supplemental bundle at tab 15?
What's the topic?
I'm so sorry, yes, I should have said. This is recognition and knowing that recognition of the trustee was a real issue before Mr. Justice Adam Johnson.
Okay, thank you. So supplementary bundle, tab 15.
Tab 15, page 237.
Yeah, this is Duncan 4 that we've been referred to.
This is the witness statement in support of the application, the sort of fast-tracked application to obtain a quick release.
Yeah.
And at page 19, you will see that Ms. Duncan refers to the fact that Mr. Vesnin had not taken any steps to substantiate his objection.
Paragraph 19.
Paragraph 19.
Yeah.
And he's not seeking to have his role as bankruptcy trustee recognised. And in there, this is just echoing what they said in their trial skeleton, that you don't need to worry about Mr. Vesnin, he has not yet been recognised in England. The point here being that by the time the parties got before Mr. Justice Adam Johnson, they knew full well that recognition was an issue, and it was an issue that was going to be addressed by Mr. Vesnin. And you may recall that I showed you the recital, which no doubt Queeld and Meister had put into the order, the consent order, which was put before Mr. Justice Adam Johnson. And that's the recital on page 214 of tab 9 of the supplemental bundle. At the top of the page, without prejudice, the claimant's entitlement to challenge the standing of Mr. Vesnin and or NBT and do not constitute a waiver of such entitlement. NBT had a judgment, and the question was, how were they going to get that recognised? Mr. Vesnin had an appointment and a bankruptcy order, and they were reserving their right to argue that.
Sorry, give me that reference again.
It's
Core
top of page, it's core bundle, tab 9, page 214 at the top. I'm so sorry, it's the supplementary bundle. I apologise.
Oh, thank you.
So recognition was always something which had flagged up, which would have to happen in order for Mr. Vesnin to have voice. And I don't accept that there was any question of him, there just being a serious question as to whether he should be recognised. To participate, he had to be recognised. There's any doubt about that. If he's not recognised, he's got no more interest in the case than a walker by in the street. It is only his capacity as a bankruptcy trustee that gives him any interest at all.
So is this right? You'd say whatever might happen in a case of extreme urgency where the court might sort of roll up the question of recognition and relief on an arguability basis and grant whatever interim relief appeared to the court just and convenient under the Courts Act. When things are being played out in at greater length, you would expect an application to be made for recognition, and it was indicated that there was going to be, well, people were reserving their right to challenge it.
And they reserved them before the Tomlin order and afterwards.
So how does that help us to construe the Tomlin order? Remind me.
Because...
And I'm not saying you're wrong.
No.
Don't get me wrong about that analysis.
No.
But I'm just saying, how does it help us analyse the Tomlin order?
Because going into the trial and immediately prior to the Tomlin order, as I mentioned earlier, there were two specific, particular individuals who looked as if they'd put their heads above the parapet. They were both foreign office holders. One was the liquidator of Morendo, which was the Cypriot company, and the other was Mr. Vesnin. And it was recognised that neither was recognised, and it was acknowledged that neither was recognised, and that they would need to be recognised in order to participate. And it's not a surprise that that should be dealt with within the Tomlin order process, either in the Eurasia proceedings or by an application which in fact was made to the insolvency court. But either way, they had to persuade a court that they were properly appointed.
Right, that's recognition. Anything else?
And a related point, if I may, it was said, my learned friend was asked to explain why it was that expert evidence was referred to in that order of the 13th of March. And there is some answer to that, because in the note of the judgment of Mr. Justice, the Simmons note on page 70 of the supplementary bundle, Mr. De Cruz made submissions to the effect that, from his point of view, his client may want.
Where are we looking?
It's on page, I think it's page 82. Sorry. Yes, at 8 point.
Page 82, yeah.
8.5c. I thought you should see that. That might explain, because of course Mr. Vesnin wasn't before the court, but but NBT by Mr. De Cruz was. And I assume that Mr. De Cruz had some say in the consent order, its terms.
Yes.
Just to respond quickly on the submission that was made about this not being an interpleader, to be fair, absolutely fair to my learned friend Mr. Harrison, he has only ever used the phrase, it is akin to an interpleader. He has not pretended at any time that this is on all fours. It isn't, clearly. But what he is saying is that he is on the sidelines. He has an interest because he wants to be protected. That's why he's here. He wants to make sure that he continues to be protected. But he is allowing others to fight out the question as to whom the release of these certificates, if anyone, should be determined. And it is also not right that he ceases to have any interest in this. He has the supreme interest and the supreme right to agree to the release. If at any time he considers, Eurasia consider that they are protected and that they are not susceptible to any claims, it is within their gift to say, I will consent to the release of the undertaking. And that's very real as a power, because it really underlines the fact that it's primarily Eurasia which is protected by the process. And I would say that the intention of the parties, objectively ascertained, was to replace the absence of a counter-indemnity with what was perceived to be a form of immunity, reasonably perceived to be a form of immunity, by bringing all known objectors into the corral and allowing them to make their claims. My penultimate point is relates to what my learned friend said about the dispute provisions in the Tomlin order.
The which provisions?
The dispute provisions, I'm
Oh,
sorry.
yeah.
Mr. Vesnin was a known, he was not a known unknown or an unknown unknown, he was a known.
And the transcriber is going to have a real field game with that. Do you want to try that again?
I think I should. Yes, I'm sorry. Mr. There was reference to people who and claims that were unknowable. There was reference to the parties not knowing who might come forward. All of that overlooks the fact that it was only 2 weeks earlier that the trustee had obtained his judgment in Russia against Queeld, relating to the Queeld shares. And that during all of that, that is 2 weeks before the Tomlin order was completed, and during the whole of that litigation, somehow or other, Queeld and MySpare had managed not to disclose to the trustee that in England they were fighting to get hold of the only known assets of Queeld without telling him. And so the moment he found out, it was inevitable that he would come forward as he did. And the last point, if I may, by way of reply, is my learned friend didn't take you to the judge's judgment at all, I don't think. And can I just remind you that so far as Mr. Morgan was concerned, he thought that the hearing that was listed before him was a final determination. Should have been, was intended by Mr. Justice Johnson to be a final determination of the question as to whom the certificate should be released. And if I can ask you just to turn for the last time to his judgment, which I think is in the core bundle, tab 5, page 57. And could I just delve straight into it? It's page 68 of the core bundle. Paragraph 61. And this is just a conclusory paragraph as a result of what he said earlier.
Paragraph which?
61 on page 68.
61.
Yes, please, Mark.
My page 68 is
Oh, have I got a... Is it 69? I'm so sorry.
69.
Paragraph 61.
61. The primary function of the DINAX jurisdiction.
Being to provide a determination giving rise to an issue of estoppel is consistent with the judge envisaging that there would be a final determination of the legal issues between the parties at this hearing. And that's when he goes on and says, of course, if the nature and scale of the issues or the state of the evidence was such that it was not going to be practical or appropriate for the court to try to make such a final determination in these proceedings, and then off he goes. But he plainly understood, and I would say correctly, that Mr. Justice Adam Johnson had envisaged that that was going to be the final hearing. Mr. Justice Adam Johnson having decided that the trustee qualified in all respects to raise the objection and that this was the hearing when it was going to be done. And that is, I would respectfully say, entirely consistent with Simmons and Simmons' note of his judgment and with his order, the direction for expert evidence and the 2-day time estimate. And you've heard my submissions as to why that time estimate should not have been given.
Yeah.
Unless I can assist further.
I don't think so. Thank you very much. No, thank you very much. Yes, Mr. Harrison, I think.
Thank you, my lord, my lady. I think I only have 5 minutes, if I may just deal with 2 points shortly.
2 points.
First relates to DINAX, coming back to points raised shortly after 10:30 this morning by Lord Justice Snowden. And the second relates to the skeleton arguments, the point your lordship, Lord Justice Coulson raised about the availability of those from the trial, on which I may be able to assist from my recollection of how those were dealt with back in November 2023.
Okay.
Just a few words then on DNACs first of all. It's used here loosely as a shorthand term to refer to the principle behind it. By analogy, and particularly that's referred to in paragraph 100 of the judgment of Lord Justice Snowden, with which Lady Justice Falk agreed, which, if you wish to turn it up, is in the authorities bundle, tab 45, page 1231.
Which of the authorities bundle?
The main one, the first one.
I think the question might have been directed as to which file.
Oh,
It's the third.
Tab 45.
It's tab 45 of the main authority.
Yeah. So it's the third file.
Relevant paragraph is at page 1231 of the bundle pagination, paragraph 135.
Yeah.
And if your lordships and your ladyship might just read that, I'll then make the point that I was going to make by reference to it.
Yeah.
Can we just put this into a context before you do, just in my own defence? The point I was actually making here follows basically a warning to people that you shouldn't come to court thinking you can buy wholesale immunity from claims by just asking the court to take a quick look at a proposed transaction and say, hey, presto, for all purposes, I'm free clear. The point I was making, 130, 131, for example, is that there may be very many cases where the court just says, on your bike, I'm not going to do anything which would suffice to confer, quotes, immunity, because it would require, in effect, me to try a claim. And then in that context, I was saying, and what's more, you'd have to join all the relevant parties who might need to be bound to such a claim in some way or shape or form to get even the vague prospect of getting an issue estoppel off the ground. So this comes at the end. This comes at the end of a real warning to people that the process, what seems to have been happening, is that people were coming to court, putting an incredibly complex transaction in front of a judge, saying, "Does that look all right to you, Judge?" The judge says yes, and then subsequently, when anybody complained about it, they said, "Well, the court blessed it, so you can't sue for anything." And this was at the end of that. I mean, I think that's what I was saying.
Yes, my lord.
I can concur.
Right. Yeah, and 135 was just making the additional point in relation to that, that, you know, for example, if an office holder wanted to go to court and say, well, I'm about to sell the house, or sell the entire shooting match, all creditors ought to very least either to be joined or to have an opportunity to appear, because otherwise how can they possibly have an issue estoppel asserted against them when they say subsequently the trustee or the office holder sold it and undervalued?
Yes.
Now that's the context of this paragraph, I think.
My lord, my lady, absolutely, if I may say so, absolutely. It comes at the end of a long passage in which your lordship and your ladyship consider the various principles, that immunity, as your lordship identified, is not really the term anyway. It's not a question of granting immunity to someone. These are all different species of the so-called portmanteau term for res judicata, to which Lord Sumption referred in the Virgin Atlantic Airways case of paragraph 17, to which your lordship refers in your judgment in Denax. These are all species of that broad res judicata jurisdiction, which has its various components identified by Lord Sumption there, with which your lordship and your ladyship agrees, and obviously in Denax. One element of that is the abuse of process jurisdiction, such that if a person has an opportunity to come to court to assert a claim and they don't take that opportunity, the court may subsequently shut them out from raising that claim later because they had the chance to do so at some earlier stage. And that is the matter with which Eurasia is concerned. Eurasia, of course, is not a trustee. We're not liquidators or administrators like the position in Tenax. We have no statutory right to come to court to seek directions, nor some procedural right under the CPR. The directors are fiduciaries and have therefore an analogous position, but they're not trustees or liquidators or administrators. But what Eurasia was doing...
Yeah, and just to be clear about that, I mean, ingenious though this whole idea may have been thought to be, I mean, directors who know their company might face a claim can't just come banging on the court's door and say, "Ooh, this is all a bit difficult. We want to have you, court, supervise a process that we can advertise for claims, and then try and shut out anybody who subsequently wants to sue us or the company." I mean, that's just not the way the world works.
Yes, directors take their own commercial decisions, otherwise the court would be clogged up with endless applications by directors to pass the phrase to the court. But
I mean, does this mean that we should be construing what you were attempting to do by the Tomlin order quite narrowly?
well, not too narrowly, because the position, as far as Mr.
Not
Vesnin
too narrowly,
is-
no, but narrowly.
well, the position was to give Mr. Vesnin the opportunity, which he's taken, to come to court to raise his claim, and that was why, under that Tomlin order, the period of almost 4 months, quite a long period, was given for claims to emerge. So shortly, just 2 weeks before that Tomlin order was made, when the matter was about to go to trial, the order from the Russia court, 31st of October, was made.
See, what I think, unless I've misunderstood him, and I'll paraphrase his arguments now down this badly, so I hope he'll forgive me, but he says, look, you tried and failed to get a wide-ranging indemnity for the issue of share certificates, but you had a process under the Tomlin order instead. And we should construe the Tomlin order as designed to give you, by court process, the equivalent of the wide-ranging indemnity that you haven't got. And he says, I think, the only way that you would get that from a court-ordered process is if what this gave rise to was a full-blown resolution of any and all issues that might be raised by somebody coming forward by whatever means the court devised. But since you would only get, quotes, immunity at the end of such a long process, it must be implicit that the undertaking not to release the shares lasts until the end of that process, whatever it is.
It would
I
last.
think that's his argument, unless I've misunderstood it.
That is indeed what we learned from Mr. Davis.
So
says.
he'd say, you know, you hoist, or somebody else anyway is hoist by your petard, that you were trying to get a wide-ranging protection, and that's the matrix against which the Tomlin order needs to be construed. I mean, do you say you were trying to get that or not?
The protection that Eurasia was seeking to obtain was to allow anyone who wished to raise a claim to raise that claim, and then to see how the court would deal with that claim, to give that person the opportunity to engage with the court to assert their claim. How the court would then deal with that claim would not be a matter for Eurasia, that would be a matter for the court. And if the claim would take a long time or not, the court would have to consider how best to deal with that. It might give a chance for someone to come to court to obtain injunctive relief. That's been discussed in this court this morning for Mr. Vesnin to do that. It might give him a chance to go to Cyprus and obtain some sort of relief out there. But the idea was to give the opportunity for that 4-month period for anyone who wished to come forward, including Mr. Vesnin, who has come forward, to be able to raise with the court how best their claims could be addressed.
But just giving that opportunity wouldn't give Eurasia any form of immunity.
That would depend on how the court were then to engage with that opportunity. And what
just-
directions were then?
Just
given?
say you'll have to go off to Cyprus to litigate it. That's it.
Yes.
Release the share certificates. That wouldn't give you any immunity, would it?
It may give some immunity, but immunity may not be the right word anyway, but it may enable Eurasia to say that there will be an abusive process later for someone to claim against Eurasia, where they have been given no opportunity at all to try to prevent the certificates being handed over to Q and M, either by seeking an injunction, whatever else they may wish to do. So it's designed to give that opportunity for claims to be flushed out and to come forward, to enable Eurasia to have that protection. And it is therefore to raise that abusive process argument, which could then be deployed later. If the person were to say they had no chance at all to prevent those certificates being released to Queeld and MySpare. And then that's the opportunity given to Mr. Vesnin, which he has taken.
I mean, I don't want to get into it particularly now. Well, no, I don't want to get into it now actually, because you've got a problem. Yeah.
Is there anything else on the first point?
No, unless I can assist further on that.
No, thank you very much. And so the second point is the skeleton argument point.
Thank you. Very, very shortly on that, the timing of that was the trial was due to begin on the 13th of November 2023. My recollection is that the judge, Mr. Robin Voss, sitting as a deputy judge, was reading on that day. The Tomlin order was made on the 14th of November, which is the day that the trial was due to begin in court. And one sees that from the Tomlin order itself at tab 10 of the core bundle, page 163, which recites, I think the trial was scheduled for the 13th onwards of November, and the order was made on the 14th. Now, I'm not quite sure where that leaves the question as to whether the skeletons therefore had been deployed already, because the judge was reading them, albeit we hadn't been into court, so that would not happen until the 14th. But a further complication, I'm afraid, is this. My recollection is that at the PTR, which I think was in September 2023, an order was made on the application of Queeld and MySpare for the skeletons not to be publicly available, and for anyone who wished to see them to apply to do so under CPR 5.4 on an application to Queeld and MySpare. And the reason for that was because there was a confidentiality protocol in place protecting some of the documents that had been disclosed by Queeld and MySpare, and some of those documents were referred to in the skeletons, and the skeletons therefore had that protection. So anyone, so whether or not they became available on the 13th of November, they were still protected by the need for someone to apply for court for permission on application to Queeld and MySpare.
So some of the documents in the bundles, the trial bundles, were confidential.
Were also protected by that confidentiality protocol.
Yes, but importantly for the purposes, the skeletons were.
The skeletons could only, my recollection is, they could only have been obtained on an application for permission. And the reason now that Mr. Vesnin has them is because Queeld and MySpare themselves, as your lordships and your ladyship know, put them into the bundle for the hearing before Mr. Justice Adam Johnson last March. And Mr. Margolin, at that time acting for Queeld and MySpare, himself referred the skeletons. Your lordship and ladyship has seen that in the note to the hearing before Mr. Justice Adam Johnson, I think in particular in paragraph 4.4, page 73 of the supplemental bundle, Mr. Margolin, I think, referred to my skeletons. That's how they have now become available to Mr. Vesnin. I think going back to November 2023, they would not automatically have been available to him or indeed anyone else.
So the confidentiality was waived, effectively.
was waived indeed, my lord, waived.
But in front of Adam Johnson.
When they themselves put them into that bundle and referred to my skeleton.
Yes, thank you very much.
Thank you.
I don't think there's anything else. No, thank you very much. Good. Well, we'll start with the second appeal tomorrow at 10:30 and hope that you stick to the timetable as you've done today. Thank you very much.